what I will do here is go over certain excerpts that stood out to me in the Supreme Court, Colorado Supreme Court's opinion. Before I do that, I want to clarify a few abbreviations uh, and sort of not abbreviations, but what they will be referred to as in future references when made in this ruling, what those words mean. Okay, sounds confusing. So clearly, I've started out at a in a very confusing way. I apologize for that. So I wanted to clarify that when this court opinion refers to the electors, they are talking about a group of Colorado electors eligible to vote in the Republican presidential primary. When it refers to district court or Denver district court, it's referring to district court for the city of the county of Denver. When referring to former President Donald J. Trump, they uh, just will refer to him as President Trump. And as it refers, when it says election code, it means Colorado's Uniform Election Code of 1992, sections 11101 to sections 113804. And when referring to the secretary, it means Jenna Griswold in her official capacity of Colorado Secretary of State. When referring to Section 3, it means Section 3 of the 14th Amendment of the U.S. Constitution. And when talking about Colorado Republican State Central Committee, it is collectively the interveners or CRSCC. Okay, so these are certain abbreviations that will come up, and I just wanted to clarify so you know who the court is referring to when using those short terms as opposed to the more elaborate term. So this is a really expansive opinion. It's 204 pages or something with all the dissents, but the majority opinion is 123 pages, 130 pages or so, and it really is a deep dive. At some places, it's a little repetitive, so I will try not to be repetitive. Uh, in the interest of not taking too much time. So the court starts out with giving the background and the procedural history and says that the district court issued its written final order on November 17th, finding by clear and convincing evidence that the events of January 6th constituted an insurrection and President Trump engaged in that insurrection. The court further concluded, however, that Section 3 does not apply to a president because, as terms are used in Section 3, the president is not an office under the United States, nor is the president an officer of the United States who had previously taken an oath to support the Constitution of the United States. So that's the district court's holding. Accordingly, Secretary could not conclude President Trump could not exclude President Trump's name from the ballot. So that was the district court's ruling. The Supreme Court of Colorado starts out its analysis by saying that we begin with an overview of Section 3. So it's sort of giving you a rundown. Then we address threshold questions regarding one, whether the election code provides a basis for review of the elector's claim. Number two, whether Section 3 requires implementing legislation before its disqualification provision attaches. And number three, whether Section 3 poses a non-justiciable political question. After concluding that these threshold issues do not prevent us from reaching the merits, we consider whether Section 3 applies to a president. Concluding that it does, we address the admissibility of Congress's January 6th report, the report from here on, before reviewing and ultimately upholding the district court's finding of fact and conclusion in support of its determination that President Trump engaged in insurrection. Lastly, we consider and reject President Trump's argument that his speech on January 6th was protected by the First Amendment. So then it does a reading of the first of Section 3 of the 14th Amendment and says that when it's interpreting constitutional provisions, it's this court's goal to prevent the evasion of the provision's legitimate operation and to effectuate the drafter's intent. To begin with, we read the plain language, giving its terms their ordinary and popular meanings. To discern such meaning, we may consult the dictionary definitions. If it's clear and unambiguous, we enforce it as written. We need not turn to other tools. However, if the provision of the language is reasonably susceptible of multiple interpretations, then it is ambiguous, and we may consider the textual, structural, and historical evidence put forward by the parties. And we will construe the provision in light of the objective to be achieved and the mischief to be avoided. So, stating prior precedent that they are now holding up, saying that this is the standard that we are interpreting the Section 3 of the 14th Amendment, which is part of the Constitution. Then it goes into saying that the state court has authority to adjudicate the challenge. Analyzing the relevant provisions of the election code, we conclude that the General Assembly has given Colorado courts the authority to assess presidential qualifications, and therefore that the electors have stated a proper claim under the sections mentioned. There's a lot of explanation and technical talk about the election code and how it applies and how the district court had jurisdiction to adjudicate the elector's claim under the election code, and that states have authority to assess presidential candidates' qualifications. And in doing so, the Supreme Court of Colorado quotes then Judge Neil Gorsuch, saying that in an opinion, Hassam, then Judge Gorsuch, said it is a state's legitimate interest in protecting the integrity and practical functioning of the political process that permits it to exclude from the ballot candidates who are constitutionally prohibited from assuming office. So that's kind of interesting that, this case that is almost definitely headed to the Supreme Court, and then the Supreme Court will take up, because the Colorado Supreme Court's, it might sidestep by saying that, Colorado Supreme Court didn't apply the law properly or something. But I don't know how the federal U.S. Supreme Court, the Supreme Court of the United States, would rule on a Colorado election code unless it finds that that election code is unconstitutional to begin with. I don't know how it would. We'll just have to see when it's argued, and whether the Supreme Court even touches that and just goes through the merits of the case, of whether he's disqualified or not. Supreme Court can stop and say that the state court didn't apply their laws properly, or say that that particular set of laws is not constitutional, or it may jump across and deal with the substantive issue of whether Donald Trump is disqualified or not. The Supreme Court can do whatever the hell it wants. That's what my professor used to tell me. So then we then it says the question then becomes whether Colorado has exercised this power through the election code. We conclude that it has. Section 1412044 is Colorado's vehicle for advancing these state interests. When eligible electors challenge the secretary's listing of the presidential primary ballot of a candidate who is not constitutionally qualified to assume office, Section 1412044, as exercised through a proceeding under Section 11113, offers an exclusive remedy under the election code. So, the court is saying that it has jurisdiction. The court is saying that the election code provides for the electors to bring this lawsuit, and that it is in a footnote it says the Secretary of State's duty to investigate whether a candidate meets the requirements of the office relating to the registration, residency, or property ownership, among others. So it's interesting to note that you're talking about the Secretary of State has to look for all the qualifications and whether candidates meet those qualifications or not. So why a president or former president would be excluded from that analysis, the Colorado Supreme Court doesn't find good reason for. So this Colorado Supreme Court says, we conclude that certifying an unqualified candidate to a presidential primary ballot constitutes a wrongful act that runs afoul of the Colorado law and undermines the purposes of the election code. Reading the election code as a whole, then, we conclude that qualified in this mentioned section must mean at minimum that a candidate is qualified under the U.S. Constitution to assume the duties of the office of president. So the court concludes that under the election code, qualified candidates for the presidential primary are those who, at a minimum, are qualified to hold office under the provisions of the U.S. Constitution. We perceive no logical distinction between a disqualification from office and a qualification to assume office, at least for the purposes of the law, the Colorado law mentioned here. Rather, as discussed above, those provisions require all presidentially primary candidates to be constitutionally qualified before their names are added to the presidential primary ballot pursuant to the law mentioned. Several courts have upheld states' exclusion from ballots of presidential candidates who fail to meet the qualifications for office under Article 2. So the Colorado Supreme Court provides an extensive record of why Colorado law applies and why Colorado Election Code allows Colorado's courts through challenge brought under these sections to assess the constitutional qualifications of a candidate and to order the secretary to exclude from the ballot candidates who are not qualified. These provisions advance Colorado's legitimate interest in protecting the integrity and practical functioning of the political process by allowing the secretary to exclude from the ballot presidential candidates who are constitutionally prohibited from assuming office. Quick water break. So we're seeing, as I'm reading through this, I've already made it to page 50, and we're still talking about this election code and how it applies. So you see that the Colorado Supreme Court really goes into the electors' standing in bringing this lawsuit. I believe, in a sense, because the Colorado Supreme Court sees this case going to the Supreme Court of the United States, and Supreme Court has a habit of using standing and ripeness and other justiciability factors to say it's not the right time, or the person bringing the case doesn't have the right, is not, doesn't have standing. So, or, it's a political question, and, there's no way of judicially. Um, so this court, the Colorado Supreme Court, addresses all of those concerns, and I believe it, in a way, it sequesters the Supreme Court to rule on the substantive matter. Excuse me. So the talking about Section 3, the only mention of congressional power in Section 3 is that Congress may by a vote of two-thirds of each house remove the disqualification of a former officer who had engaged in insurrection. Section 3 does not determine who decides whether the disqualification has attached in the first place. Section right. I'm scrolling through because there's more descriptions about this uh, uh, case uh, being just so goes into why it's justiciable, um, because uh, President Trump says that it presents a non-justiciable political question, but this court doesn't agree with that. Uh, you know, uh, not going to go into the, because I haven't highlighted those areas. I want to give you an understanding of uh, what the conclusions are for the court. A conclusion that the presidency is something that, so now we go into the presidency is an office, and it applies to the president. Uh, uh, so, so party, let's see. A conclusion that the presidency is something other than an office under the United States is fundamentally at odds with the idea that all government officials, including the president, serve we the people. This reading of the language of Section 3 is, moreover, more consistent with the Constitution as a whole, saying that the phrase under the United States is that the drafters meant simply to distinguish those holding federal office from those held under any state. We conclude, therefore, that the plain language of Section 3, which provides that no disqualified person shall hold any office, civil or military, under the United States, includes the office of the presidency. This textual interpretation is bolstered by constitutional context and by history surrounding the enactment of the 14th Amendment. Indeed, Americans have referred to the president as an officer from the days of the founding. And many 19th century presidents were described as or called themselves Chief Executive Officer of the United States. A construction of Section 3 that would nevertheless allow a former president who broke his oath not only to participate in the government again, but to run for and hold the highest office in the land is flatly unfaithful to the section's purpose. We therefore conclude that officer of the United States, as used in Section 3, includes the president. The presidential oath is an oath to support the Constitution. Because, Donald Trump has parsed the meanings, saying that, taking the oath of office for the president because it's different from other offices, it doesn't apply. Essentially saying by many words that the presidential office is above the law. So the Colorado Supreme Court says the most obvious and sensible reading of Section 3, supported by text and history, leads us to conclude that 1, the presidency is an office under the United States. Two, the president is an officer of the United States. And three, the presidential oath under Article 2 is an oath to support the Constitution. President Trump asks us to hold that Section 3 disqualifies every oath breaking insurrectionist except the most powerful one, and that it bars oath breakers from virtually every office, both state and federal, except the highest one in the land. But results are inconsistent with the plain language and history of Section 3. We therefore reverse the district court's finding that Section 3 does not apply to a president and conclude that Section 3 bars President Trump from holding office of president if its other provisions are met, namely if President Trump engaged in insurrection. So then it goes into stating, essentially ruling on Donald Trump's appeals. Donald Trump appealed by saying that the district court erred in admitting portions of the January 6th report. The Colorado Supreme Court says no, it didn't. It says the district court found that Mr. Heapy's testimony on this subject to be credible and held that any perceived animus of the committee members towards Trump did not taint the conclusions of the January 6th report in such a way that would render them unreliable. We see no abuse of discretion. And so it admitted, so it says that the district court was not wrong when it accepted some portions of the January 6th report. So it says there was no abuse of discretion. President Trump has not met his burden of demonstrating that, contrary to the evidence the district court highlighted, the report suffered from motivation problems. So while Donald Trump may claim it, he hasn't set anything forth to explain that what he means by that there were reliability issues with the January 6th committee report. And so he hasn't provided any evidence for it. So finally, we note that at oral argument, President Trump's counsel, while not providing a specific definition, argued that an insurrection is more than a riot, but less than a rebellion. And then it goes into explaining the word insurrection. It suffices for us to conclude that any definition of insurrection for the purposes of Section 3 would encompass a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish a peaceful transfer of power in this country. The required force or threat of force need not involve bloodshed, nor must the dimensions of the effort be so substantial as to assure probable success. Moreover, although those involved must act in a concerted way, they need not be highly organized at the insurrection's inception. Excuse me. The question thus becomes whether the evidence before the district court sufficiently established the events of January 6th constituted a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish the peaceful transfer of power in this country. We have little difficulty concluding that substantial evidence in the record supported each of these elements, and that the district court found the events of January 6th constituted an insurrection. The court also found that many in the mob stole objects from the Capitol's premises or from the law enforcement to use as weapons, including metal bars from police barricades and officers' batons and riot shields that had throughout the day the mob repeatedly and violently assaulted police officers who were trying to defend the Capitol. The fact that actual and threatened force was used that day cannot reasonably be denied. So The court here has a strong statement. The fact that actual and threatened force was used that day cannot reasonably be denied. Substantial evidence on the record further establishes that this use of force was concerted and public. The mob coordinated the effort. Upon breaching, it immediately pursued its intended targets. Finally, the substantial evidence in the record showed that the mob unified the purpose was to hinder or prevent Congress from counting the electoral votes as required by the 12th Amendment and from certifying the 220 presidential election. That is to preclude Congress from taking the action necessary to accomplish a peaceful transfer of power. This breach caused both the House and the Senate to adjourn, halting the electoral certification process. In addition, much of the mob's ire was directed at the vice president, which included threats of violence, was directed at Vice President Pence, who in his role as president of the Senate was constitutionally tasked with carrying out the electoral count. In short, the record amply establishes that the events of January 6th constituted a concerted and public use of force or threat of force by a group of people to hinder or prevent U.S. government from taking the actions necessary to accomplish the peaceful transfer of power in this country. The Colorado Supreme Court is very forceful in its language in talking about how this was an insurrection, and then it goes on and goes on to explaining what engaged in means. And it states that the Attorney General's view, when individuals acting in their official capacities act in furtherance of a common unlawful purpose or do an overt act from the purpose of promoting the rebellion, they have engaged in insurrection or rebellion for Section 3 disqualification purposes. There's a powerful quote from Chief Justice Marshall quoting that if a body of men can be actually assembled for the purpose of effecting by force a treasonable purpose, all those who perform any act, however minute or however remote, from the scene of action or who factually leagued in the general conspiracy are to be considered traitors. Accordingly, the district court, we conclude that engaged in requires an overt and voluntary act done with intent of aiding or furthering the common unlawful purpose. The force of the term to engage carries the idea of active rather than passive conduct and of voluntary rather than compulsory action. The question remains whether the record supported the district court's finding that President Trump engaged in the January 6th insurrection by acting overtly and voluntarily with the intent of aiding and furthering the insurrectionist common unlawful purpose. Substantial evidence in the record showed that even before the 2020 election, President Trump was laying the groundwork for a claim that the election was rigged. President Trump then lost the election, and despite the facts that his advisors repeatedly advised him that there was no evidence of widespread voter fraud and that no evidence showed that he himself believed the election was wrought with fraud, Trump ramped up his claims that the election was stolen. Trump sought to overturn election results by directly exerting pressure on Republican office holders in various states. He was well aware of these threats, particularly after Georgia election official Gabriel Sterling issued the public warning to President Trump to stop inspiring people to commit potential acts of violence or someone's going to get killed. But President Trump continued to fan the flames of his supporters' ire with the Stop the Steal movement, with full knowledge that this sometimes with full knowledge of these sometimes violent events, Trump sent following tweet on December 19, 2020. That was the "will be wild" tweet, saying statistically impossible to have lost the 2020 election. Big protest in DC on January 6th. Be there, it will be wild. So here on page 108 of the Colorado Supreme Court opinion, it brings up the "will be wild" tweet and how that goes to showing that Donald Trump was engaging in the insurrection. Far-right extremists such as Proud Boys and Oath Keepers saw that tweet as a call to arms, and they began to plot activities to disrupt the joint session of Congress. So the court goes into and factually lays out, as the district court did, what Donald Trump did. Vice President Mike Pence and points out the pressure put on Vice President Mike Pence, saying that Trump tweeted on the morning of January 6th for Mike to do the right thing. Do it, Mike. It's time for extreme courage. These tweets had the obvious effect of putting a significant target on Vice President Pence's back, focusing President Trump's supporters on the vice president's role in overseeing the counting of the electoral votes and certifying the 2020 presidential election to ensure the peaceful transfer of power. So Colorado Supreme Court over and over again goes back to that that obstructing of the peaceful transfer of power, and it does so because it wants to reiterate the importance of what Donald Trump did. Trump then gave a speech in which he literally exhorted his supporters to fight at the Capitol, and the Supreme Court of Colorado lists these in their opinion. We've gathered together, and I'm going to read these quotes because it's important. Take a quick water break before that. So you see that this is a really thorough and just very addresses every single issue that the Supreme Court could address in an effort to sidestep, but can't sidestep the substantive issue. I mean, it can, but it makes it difficult for the Supreme Court to sidestep the substantive issue of whether Donald Trump is disqualified under Section 3 of the 14th Amendment or not. Excuse me. So now I'm going to read you these messages that Donald Trump said, what Donald Trump said at the January 6th speech, Stop the Steal speech. We're gathered together in the heart of our nation's capital for one very basic reason: to save our democracy. Republicans are constantly fighting like a boxer with his hands tied behind his back. It's like a boxer, and we want to be so nice. We want to be so respectful of everybody, including bad people. And we're going to have to fight much harder. Now it's up to Congress to confront this egregious assault on our democracy. And after this, we're going to walk down, and I'll be there with you. We're going to walk down to the Capitol, and we're going to cheer on our brave senators and congressmen and women. And we're probably not going to be cheering so much for some of them, because you'll never take back our country with weakness. You have to show strength, and you have to be strong. When you catch somebody in a fraud, you're allowed to go by very different rules. The most corrupt election in the history, maybe, of the world. This is not just a matter of domestic politics. It's a matter of national security. And we fight like hell. And if you don't fight like hell, you are not going to have a country anymore. And the Supreme Court of Colorado says, unsurprisingly, the crowd at their lips reacted to President Trump's words with calls of violence. Throughout these several hours, Trump ignored pleas to intervene and instead called on senators, urging them to help delay the electoral count, which is what the mob, upon Trump's exhortations, was also trying to achieve. Finally, at 4:17 p.m., Trump released a video urging the mob to go home. Trump concluded by encouraging the country to remember this day forever. That was the other tweet he sent afterwards. We conclude that the foregoing evidence, the great bulk of which was undisputed at trial, established that President Trump engaged in insurrection. President Trump's direct and express efforts over several months, exhorting his supporters to march to the Capitol to prevent what he falsely characterized as an alleged fraud on the people of this country, were indisputably overt and voluntary. Moreover, the existence amply showed that President Trump undertook all these actions to aid and further a common unlawful purpose that he himself conceived and set in motion: prevent Congress from certifying the 2020 presidential election, to stop the peaceful transfer of power. Again, the peaceful transfer of power. As our detailed recitation of the evidence shows, Trump did not merely incite the insurrection. Even when the siege on the Capitol was fully underway, he continued to support it by repeatedly demanding that Vice President Pence refuse to perform his constitutional duty, and by calling senators to persuade them to stop the counting of the electoral votes. These actions constituted overt, voluntary, and direct participation in the insurrection. He exhorted them to fight to prevent the certification of the 2020 presidential election. He personally took action to try to stop the certification, and for many hours, he and his supporters succeeded in halting that process. So here we have the Supreme Court of Colorado lining out exactly how Donald Trump engaged in insurrection and agreeing with the district court's opinion below. And then it goes, the next section discusses that President Trump's speech on January 6th was not protected by the First Amendment right to freedom of speech. And that is effectively the Brandenburg test. And I have talked about the Brandenburg test before quite elaborately, and the Supreme Court of Colorado here does the same. It goes over the Brandenburg test, and it applies the Brandenburg test to the facts of this case. You can tell my dog is a little looking for attention at the moment because he's making noise. I apologize. You can blame him. As the Supreme Court explained in Brandenburg, the First Amendment's constitutional guarantees of free speech do not permit a state to forbid or prescribe advocacy of the use of force or law or of law violation, except where such an advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. So the test, according to Brandenburg and its progeny, which is Waguma versus Trump, Waguma versus Trump, and the test is that the speech is explicitly or implicitly encouraged the use of violence or lawless action. The speaker intended that the speech would result in use of violence or lawless action, and the imminent use of violence or lawless action was likely result of this speech. And then it goes through and it says that each of these elements are met by Donald Trump's speech. By considering and placing value in the absence of corroborating evidence of Evers' violent intentions, the court, I apologize. Okay. True threats and incitement are doctrinally distinct, but true threats are the closest cousin of incitement under the First Amendment. And talking about the difference between what is imminent lawless action. Uh, then and multiple federal circuit courts conducting a true threat analysis confirm that common sense suggests when assessing whether someone means to threaten another with unlawful violence, we sometimes need to consider more than behavior exhibited on one occasion. So too with incitement. Context matters. We conclude that it is appropriate for the district court to consider Trump's history of courting extremists and endorsing political violence as a legitimate and proper, as well as his efforts to undermine the legitimacy of the 2020 election results and hinder the certification of the electoral college result in Congress. So the court applies the Brandenburg test and says that uh, effectively that Donald Trump is disqualified because of it. So I'm going to read some portions of it. According to the court summary, one, violent far right extremists understood President Trump's calls to fight, which most politicians would mean only symbolically, were when spoken by Trump, literal calls to violence by these groups, while President Trump's statements negating that sentiment were insincere and existed to obfuscate and create plausible deniability. So he talks about how the speech also took context in that pattern of how he says violent rhetoric and then just throws in a little piece, garnish on top to cause plausible deniability. The district court found that Donald Trump encouraged and supported violence before and after the 2020 election, and calling the election fraud on the American public, saying that the Democrats stole the election. Many states and state officials targeted by Donald Trump were subject to harassment and violence threats because of these lies. And the Colorado Supreme Court recognizes it. He used the words fight or variations of it 20 times during his ellipse speech. He declared that when you catch somebody in a fraud, you are allowed to go by different rules. And he claimed that our election victory was stolen. In short, the district court found that Donald Trump's speech on the lips was understood by a portion of the crowd as a call to arms. And the district court is not the only one to come to that conclusion. And it says that the U.S. District Court for the District of Columbia also held that the president incited and encouraged the use of violence and lawless action to disrupt the peaceful transfer of power. So here, the Colorado Supreme Court says, our independent review of the record in this case brings us to the same conclusion. President Trump incited and encouraged the use of violence and lawless action to disrupt the peaceful transfer of power. The tenor of President Trump's messages to his supporters in exhorting them to travel to Washington, D.C. on January 6th was obvious and unmistakable. The allegedly rigged election was an act of war, and those victimized by it had an obligation to fight back and to fight aggressively. And President Trump's supporters did not miss or misunderstand the message. The cavalry was coming to fight. So then it goes into the other elements of the Brandenburg test. Speaker intends that his speech will result in the use of violence. So it requires specific intent, presumably equivalent to purpose or knowledge, and defining acting purposely. So it's considering whether Donald Trump's exhortations on the clips of fight like hell and his urgings to his followers to go to the Capitol and go by different rules were intended to produce imminent lawless action. So the district then it says that the district court found that President Trump knew that his supporters were angry and prepared. He, uh, President Trump's response to the events following the speech also showed that he intended the actions of the mob on January 6th. Based on these findings, the court concluded that Trump acted with the specific intent to incite political violence and directed at the Capitol with the purpose of disrupting the electoral certification. The district court found that Trump knew before he gave his speech that there was potential for violence on January 6th. It also found that Donald's conduct and tweets, which we outlined above, from the time he was told the attack on the Capitol at 1:21 p.m. until Congress reconvened later that night, indicated his intent to produce lawless, violent conduct. We agree that Trump intended that his speech would result in the use of violence or lawless action on January 6th to prevent the peaceful transfer of power. Again, peaceful transfer of power. He set it in motion and then he stood back and let the fighting happen, despite having the ability and authority to stop it, thereby confirming that this violence was what he intended. Then it goes to the next element, likely to incite or produce imminent lawless action. Finally, for speech to be unprotected, we must conclude that the imminent use of violence and lawless action is likely the result of the speech. And the district court found that one of his the expert who testified about examples of these patterns of call and response that Trump developed that and used to incite violence by his supporters. Professor Simi reviewed Trump's relationship with his supporters over the years, identified a pattern of call for violence that his supporters responded to, and explained how that long experience allowed Trump to know how his supporters responded to his calls for violence, using a shared language that allowed him to maintain plausible deniability with the wider public. He retweeted a Kylie Jane Kremer's tweet saying the cavalry is coming, Mr. President. So by saying that, Professor Simi said, President Trump's December 19th will be wild tweet had an immediate effect on the far-right extremists in the militia who viewed the tweet as a call to arms and began to plot activities. These findings support the conclusion that Trump's calls for imminent lawlessness and violence during his speech were likely to incite such imminent lawless violence. When Trump told his supporters that they were allowed to go by very different rules, and that if they did not fight like hell, they would not have a country anymore, it was likely that his supporters would heed his encouragement violently. We therefore hold that the Brandenburg test is met. So here we have the Supreme Court of Colorado concluding, saying, we conclude that because President Trump is disqualified from holding the office of president under Section 3, it would be a wrongful act under the election code for the secretary to list President Trump as a candidate on the presidential primary ballot. Therefore, the secretary may not list President Trump's name on the 2024 presidential primary ballot, nor may she count any write-in votes cast for him. And then it goes on to say that it stays the ruling until 4th of January, when the deadline is for the secretary to certify the content of the primary ballot. And if Donald Trump appeals to the Supreme Court of the United States before that, then this stay on this ruling would continue until the Supreme Court came with its ruling. So, that's 133 pages of the opinion. And I'm not going to go into the dissents. each of the dissents deal with the election code, and the Colorado, one of the both two justices of the Colorado Supreme Court actually talk about the election code and jurisdictional issues. And one of the justices talk about how one of the cases, a circuit case that is not binding on the Colorado Supreme Court, held that Section 3 cannot be applied without due process of law. And so that was the reason that they dissented. But the 4-3 opinion majority ruled that Donald Trump is not is disqualified from holding office in the United States, and therefore cannot be on the Colorado Republican primary ballot, and therefore the other ballot. So with that, I end this marathon that has gone on for 51 minutes, but it's quicker than you having to read 130 pages. Hello, Veronica. Thank you for being here. I see 4 of you are here. Good morning, and thank you for being here. If you are new, please like and subscribe and share this video if you think others would be interested in a deeper reading of the case. I have done a short video as well, which is just the summary of the holding. We now have to, there are a lot of deadlines that Donald Trump has to meet from now until January 4th. It's not just the appellate filings for the en banc full court for the gag order, which Donald Trump has appealed. Then there's the appellate expedited appellate hearing for the governmental immunity issue, and then there is the deadline of December 20th of today for Donald Trump to respond to Jack Smith's ask of the Supreme Court to hear the case of governmental immunity in the district court's criminal conspiracy case, District of Columbia, Federal District Court. So I'm shifting from that to then now there's this filing that they have to submit by 4th of January. So it's a lot of work for Donald's attorneys, but that's what they're getting paid for. And we'll now have to wait and see. This was the big thing that I was waiting for until next maybe early next month or something like that, or middle of next month, because the courts are now delivering their opinions quickly, and they now see the urgency of the moment. So with that said, I'd like to conclude. Please like, share, and subscribe, and I will talk to y'all soon.